Hi, everyone. My name is Keith McNutt, and I'm the Executive Director of the Western Region of the Entertainment Community Fund. I want to welcome everybody to today's webinar, and we hope that this will provide wonderful information as you proceed through landlord-tenant issues. We want to say a huge thank you to our colleagues at Public Counsel for being here with us. We also want to say a tremendous thank you to all of our union, guild, association, and nonprofit partners in the entertainment community who are joining us to sponsor these webinars for the community. The Entertainment Community Fund's role is to help everybody who works in performing arts and entertainment all across the country, providing safety net services for people who are in need and crisis, and services to promote long-term stability and resiliency for a lifetime in the arts. And so we're thrilled to be able to provide this kind of information, and we'll continue to do so over the course of the coming months. We know that everybody who has been affected by these fires needs support and community. And we also know that when crises like this come up, that sometimes public attention moves away from the crisis at hand onto the next crisis. And I think what the fund and all of our partners who are joining us in sponsorship want everybody to hear on this webinar is that we're not going anywhere, that we understand that this is a long-term situation requiring us to walk with you through this process for all of the months ahead, that everybody will need to get their feet on the ground and start their own individual recovery process, whether that's providing emergency financial assistance, whether that's providing information about systems that are difficult to navigate, or help with the emotional toll that all of this takes on everybody who's going through it. So we are all here together with you, and we will continue to bring resources like our colleagues at Public Counsel. And we look forward to hearing from you about other ways that we all may be able to serve. I hope you will look at all of the partners hosting this organization and see what they can offer and how we can help, because we are here for the long term. So I won't talk anymore. I want to turn it right over to our Director of Social Services, Tina Hokum, who has been doing such a wonderful job putting these together and will be hosting us and leading the conversation for the rest of the afternoon. Tina?
Thanks, Keith. Thank you. Hi, everyone. As Keith mentioned, I'm Tina Hokum. I'm the Director of Social Services for the Entertainment Community Fund. This is our third webinar that we've been able to provide in collaboration with our community partners. If you have been with us before, welcome back. And if this is the first time you're joining us, we are so glad that you're here for today's webinar, When the Smoke Clears, Understanding Your Rights as a Tenant after the LA fires. I'll be facilitating our conversation today with speakers from nonprofit interest law firm Public Counsel, who have been educating our community and working with people in the aftermath of the fires. Before we get into our content today, I'm going to quickly describe how we're going to use our webinar space. On the bottom toolbar of your screen, you will see that we have a closed caption icon down there. To utilize this feature, you need to click the closed caption icon and you would begin to see the text scroll. Also on the bottom toolbar, you will see the chat icon. Click on that icon to see the chat bar come up alongside this of your screen. Today, we are using that chat feature to share resources such as links and PDFs. Please know that you can cut and paste information from the chat into another Word document, into the notes on your phone. You can put it in an email and email it to yourself later. However, please know following today's session, we will be sending everybody information that we placed in the chat, so you are welcome to really just participate and listen. You can submit questions for our speakers today by clicking the Q&A icon on the bottom. If you want to submit an anonymous question, it is recommended to click the icon, click anonymous first before you begin to type, or you may accidentally submit a question with your name appearing. We will curate questions as they come in. We are going to make every effort to answer as many questions as we can, but there are quite a few of us on the webinar today, so we're going to do our best. If you really like a question that somebody else has placed in the Q&A, please upvote that question by using the reaction button and giving it a thumbs up. That's going to help us curate what to ask first. You will see the agenda in the chat. Our format today is going to cover and review a section of content. Then we're going to open up for questions related to that section only, and then we're going to move on to the next section. Lastly, this webinar will be recorded and available on our Entertainment Community Fund client portal and website, as well as all of our community partners will have access to it. We will be sharing the recording and the resources in a follow-up meeting for all registered participants for today. We also want to take a few minutes to highlight a couple of things. If you missed our webinar with FEMA and the Small Business Administration, that is also available on our website and our portal. The deadline to apply for FEMA is March 10th. Also on our website and client portal is our webinar with EDD on understanding disaster unemployment. The deadline to apply for disaster unemployment is also March 10th. We cannot highlight enough that if you have questions about your applications for FEMA, SBA, unemployment, or any other system, it is important to privilege the time to go to the disaster recovery centers while they are still open. We have heard that Altadena in particular is a very helpful site. When you go there, you have access to speak to a person in person. They can help you apply, navigate questions. They can review things like your FEMA application and unemployment and see if things are stuck or what you can do to help navigate the system. Also want to highlight that the Entertainment Community Fund is offering a weekly space called Recovering Together. This happens every Tuesday, noon to 1:30. It's a drop-in virtual space. It's a community gathering for our community to come together and connect, to listen and to share and be with one another during these phases of recovery. Everyone is welcome to join. The link to join is in the chat. We also want to highlight that there are weekly town hall meetings happening both in Altadena and the Palisades. There are numerous ways to stay connected and informed and to stay connected with your community. We want to state the importance of staying connected to your support system. And if you are feeling like you need help accessing support, we hope you reach out. We also wanted to call to attention to a few emergency assistant funds that have upcoming deadlines. So the LA Regional Small Business and Worker Relief Fund directly supports workers, small businesses, and not-for-profits impacted by the wildfire and storms. The deadline has been extended, and they are now accepting applications until March 12th. The link is in the chat, and you can review the website eligibility and get access to the application. Also, Restaurant Cares through the California Restaurant Foundation. Their application is open until March 31st. This is for members of our community who work in the food and beverage industry. Check out their application and eligibility and access the application online. Lastly, the LA County Household Relief Grant is open and will accept applications until March 12th. We hope that you check out that website, the eligibility, and the application. Again, we will list everything we're talking about in the chat in our follow-up email. So without further delay, let's welcome our speakers today, Gigi Lamb, Directing Attorney, and Elisa Randall, Managing Attorney, both from the Homeless Prevention Law Project at Public Counsel. Welcome, welcome. Thank you for being with us today. We are going to present our material using some slides, and we're going to begin with a brief overview of services from Public Counsel. So Gigi and Elisa, thank you so much for being with us. Let's jump right in, and I'll pass it to you.
Thank you, Tina. we can go on ahead, I think, to probably the third slide. Or maybe the second slide. I'll briefly introduce myself. My name's Elisa Randell. I'm a managing attorney at Public Counsel in the Homelessness Prevention Law Project. And Gigi also is in the Homelessness Prevention Law Project. We can go to the next slide. Just to give you a little bit of background about Public Counsel and what we do as an organization and what our project specifically does. Public Counsel is a nonprofit public interest law firm dedicated to advancing civil rights and racial and economic justice and amplifying the power of our clients through legal advocacy. The Homelessness Prevention Law Project primarily focuses on eviction defense, access to benefits, and affirmative housing litigation. We also just provided our website in case you all are curious to poke around a little bit more. We have several different projects that do various other things. Next slide. So before we get started, just a disclaimer about what we're able to do today. This is going to be a general overview of, the lay of the land for tenants' rights and landlord obligations after the wildfires. It's for informational purposes, and it is not intended to be all-inclusive or legal advice. So we ask that you try to keep your questions more general, maybe not specifically about your specific situation, because we want to be able to provide information that's helpful to everyone, but we're not able to do kind of one-on-one consultations, and we are not forming an attorney-client relationship with any of you by doing this presentation. Next slide. Okay, so just as we start out, this is basically an outline of what we intend to cover today. As a broad category, we're going to go over tenant rights and landlord obligations in the aftermath of the fires. Factors to consider when you're thinking about what your rights might be, which are where your property is located and the level of damage it incurred. We're going to go over the implied warranty of habitability, which is something that exists in all rental housing. Concerns around personal property, security deposits, rent payments and rent obligations, and relocation assistance. And then we're going to discuss some of the more recent tenant protections that have passed, including around price gouging, eviction protections, and harassment protections, which actually have existed even prior to the fires. And then finally, we'll talk a little bit about strategies for achieving your best outcome given your situation. Next slide. So in terms of important things to consider, for any tenant in the County of Los Angeles, your rights and the landlord's obligations, in other words, the law that applies to your tenancy, depends on where the property is located. That is because all of the tenant protection laws are very specific to different cities and in some cases the unincorporated county. And we're going to go over how to figure out where your property is located. The other thing that's important to consider is how much damage your unit sustained. So depending on whether it was destroyed, if it was severely damaged, or if there's some damage, but it's still possible to live in the unit, your rights and the landlord's obligations are going to vary based on that level of damage as well. So this presentation is primarily going to focus on three of the bigger or the jurisdictions that were affected by the fires. So that is the city of Los Angeles, which is Pacific Palisades, Pasadena, which has its own tenant protections law, and then unincorporated LA County, which is where a lot of Altadena is. Just in general, if you don't know exactly where you are located, we're going to provide these slides afterwards, so you can click on this link. These are two different links, and you just put your address in the search form, and if it shows up, you know that you're in the city of Los Angeles. It can be confusing because we all kind of just say Los Angeles is if, we live in LA, but There is a difference between the city of Los Angeles and the county of Los Angeles, which is a lot bigger in area, and there are several incorporated cities within the county. So for the city of Los Angeles, you can use these links to look up and see if you live there. And again, for Pasadena, if you're not sure if you live in the city of Pasadena, we've included this link that you can go to and just type in your address. And next slide. Finally, same for unincorporated LA County, which is basically any part of LA County that isn't an incorporated city. And those parts of LA County have their own specific tenant protection law. So again, we'll provide this link. You can go to this, the LA County Planning website, look up your address, and it'll tell you if it's unincorporated LA County. Okay, so this is a lot of text, I know, but this is just a general overview, and we're going to go into more detail about some of these things on this slide. But just to give you a lay of the land about one of the major things that you're considering when you're thinking about your rights right now, it's the level of damage. Generally speaking, if your unit was completely destroyed, that means that the tenancy is over. The purpose of the arrangement with your landlord is gone. So that means you do not have the right to return. There's nothing to return to. But the good thing is you also are no longer obligated to pay rent. It's pretty straightforward. You are entitled to a partial refund of January rent if you were evacuated, which many people were in this situation. If you had already paid January and you were out for the rest of the month, you should be entitled to a refund for that. And also your landlord should be returning your security deposit, which we'll go into more detail later. The harder situation is the severely damaged unit. Part of why this can be difficult is because people have differing definitions of what severe damage or severely damaged or unsafe means. But as a general principle, if the unit is severely damaged, but not destroyed, in other words, it can be repaired, but there's serious things that need to be done to remediate what's going on. You still have a tenancy, so you still have rights. Your tenancy is still in effect, but your obligation to pay rent should be suspended for the duration of time that you are unable to live at the property because it's unsafe or it's untenantable. For instance, if there's no utilities, no water, things like that, like basic, it's not livable. Similar to what we just discussed with units that were destroyed, a lot of people who are in this situation in a severely damaged unit were evacuated, and some people have not been able to return still. For January rent, that time that you were evacuated and displaced, if you had already paid January, you're entitled to that refund of that money. And then moving forward, you shouldn't be required to pay rent for a unit that you can't live in. In other words, it's uninhabitable. We're going to go into this in a little more detail. You may be entitled to different forms of relocation assistance, depending again where you live and which law applies. And if you do decide to move out, which you can, give your landlord a written notice. And again, same security deposit rules apply. It should be returned within 21 days after you move out. And again, we're going to go over security deposit in more detail later. Finally, the third category is if you've got some damage, but it's still livable. Your tenancy continues, as does your obligation to pay rent, and you may be able to negotiate a reduced rent with your landlord due to the damage, at least until the repairs are made. In this situation where there's not really severe damage, if you withhold rent, there's a real possibility that you could receive an eviction notice from your landlord. So we wouldn't suggest not paying rent in that third category of damaged, but not severely damaged. Next slide. So something to remember, again, this is like general principles. Every landlord is responsible for maintaining their rental property in a safe and habitable condition. This is for every rental property in the state of California, regardless of where you live. This includes ensuring that the property is free from debris, combustible materials, and other hazardous materials or conditions that could be fire, health, or safety hazards. It also applies not only to the structure itself, but common areas and yards. So these are quotes from state law, indicating pretty clearly that the warranty of habitability for which the landlord is responsible does apply to not just the building, but grounds and all areas under the control of the landlord. They need to be kept clean and free from debris, filth, rubbish, etc. As a general rule, if you're having bad conditions in your rental property, it's always good to document the conditions, notify your landlord, and request repairs. And we're going to provide a sample demand letter that you can work off of if to make those requests for repairs. Next slide. So one question we've been getting a lot is, how do I know if my home is safe? There's been a lot in the news and just generally about, toxic smoke and ash. And this question mark of, okay, when is it going to be safe for me to go back? What does the landlord have to do to remediate things like toxic smoke and ash? The best way to know if your home is safe is to get it inspected by a professional. Ideally, because it would be free, is for a government agency to inspect the unit and sign off on whatever repairs or remediation the landlord has done. If we understand that this has been a struggle in some areas, maybe some of the government agencies are overwhelmed, or I think in the beginning they weren't clear on whether this was something that they should be doing inspections for. But I would say keep asking, keep requesting those inspections, keep making complaints to your government agencies, because they are ultimately in charge of and responsible for going out to these properties and ensuring that landlords are complying with their responsibilities to maintain their premises. One other option that I've heard some tenants talk about is working with their landlord and the landlord's insurance company, as well as their renter's insurance company, to hire private inspectors, private remediation professionals to come out and figure out what needs to be done and get that work done. So if you have renter's insurance, if you have a good relationship with your landlord and they're working on using their insurance, that's also a good option. If your landlord is refusing to make repairs or you think the repairs that they made were not adequate, again, contact your local enforcement agency and make a complaint. There is also a remedy called repair and deduct. You are legally allowed, after giving your landlord notice of the conditions and a reasonable time to correct it themselves, you have to give the landlord enough time to, reasonably do the repairs themselves. If you've given them that time, they still haven't done it, and the amount of money that it will cost to do the repair is less than 1 month's rent, you can pay for it yourself and deduct it from the next month's rent. You could also withhold rent and say, listen, landlord, I'm not going to pay you until this gets fixed. Both of these options are available to you. We mention them with caution, however, because what could result if your landlord wants to be aggressive is they could serve you with an eviction notice, and then you may end up in a defensive position of having to defend an eviction lawsuit. So just a little asterisk for those two potential options. You could also consult with private attorneys to try to sue your landlord. That is also another option available to you if it's really bad. But again, just emphasizing, in all of these situations, just keep really detailed records, take photos, make notes, keep a record of when you've contacted your landlord, when you've contacted agencies, so that you have all of your ducks in a row and you have all of your evidence in order when it comes down to it, if you do have to engage in litigation. Next slide. So I know we keep emphasizing contact agencies, so government agencies. So we've made a list here for these 3 different places: Pasadena, unincorporated LA County, and the city of Los Angeles, different government agency websites where you can go get information. And they also have links and websites where you can actually go online and request an inspection and make a complaint. Slide. Finally, something that we've heard come up a lot is just what about my personal property? If you had personal property that was damaged and, you know, smoke filled, has ash or it's contaminated or otherwise destroyed by the fire, the compensation for your possessions that were inside the unit is really not the landlord's responsibility unless it was the damage is somehow the result of the landlord's negligence. So in a lot of the circumstances related to the fires, you know, the fires are not related to the landlord's negligence. So they're probably not going to be liable for, you know, paying you or helping you replace your personal possessions. That's what renter's insurance is generally for. So if you have a renter's insurance policy, review it, see what the coverage is like and try to go through that route to deal with your personal property. In terms of retrieving personal property, again, it's going to depend on the extent of damage to the building. Hopefully, most people have been able to go back already at this point, but just follow the guidance of the, you know, government agencies that are in charge of all of that to determine when it's safe for you to return to get your stuff. And here we'll pause for questions.
Great. Thank you so much. We do have a couple of questions. I first wanted to go back to the top, Elisa. So could you tell us who is everyone eligible to use services through Public Counsel? What's the eligibility to use services through Public Counsel?
So that is a very not easy answer.
Oh, okay.
We have a lot of different teams, and each team has different funding sources and has different ways of getting referrals.
Okay.
But maybe we can provide some written materials after the presentation. It would take too long to explain that.
Perfect. Okay. Thank you so much. Yes, we can follow up. So we do have a question. The question was, this person has windows that are opening, right? And toxic ash is coming inside. They have a newborn and are very concerned, as one could imagine, about that. And they just didn't know how to scale severely damaged, right? Or inhabitable. And was wondering if you could speak a little bit to that.
This is the question of the hour. This has been something that people have been fighting with their landlords about, and that the government agencies haven't really been fully consistent about. So, you know, I think one of the things that you can do to have like an objective measure of whether something is really dangerous is testing, right? So that's why we keep saying the best way to know is have a professional make a determination. So I know not everyone has the ability to hire a private company. I know those can be expensive, but, you know, continuing to call the government agencies applicable to your region and see if they'll come out. I think that there has been some like general guidance for, you know, just looking at I think the county's website last night, they've been starting to release some guidance of, you know, if you're within this vicinity, you know, this is what's going on. And these are the things you can do in terms of the toxicity of different materials that may be in the property. I would definitely lean on, I think they are starting to develop some more guidance around that. And I would look at the government websites to see if they might have more helpful tips.
Okay, great. And just a follow-up to the toxic ash question. Some of us, right, are managing medical issues, asthma, things of that nature that feel very exacerbated by the air quality and by the ash. And this person was wondering that if, you know, they have doctors or the insurance remediator determining that the unit is not habitable, is that sufficient? You know, is that, who gets to determine that and say that it's not habitable, therefore, I guess, like releasing the obligation to pay rent?
Is this in the context of so not habitable for a specific person because of a specific health condition?
Correct.
So the first thing I think of when you ask that is just landlords are required to reasonably accommodate tenants with disabilities. So this is like a disability discrimination type of thing. If you make a reasonable accommodation request that says, you know, I have this medical condition and because of that, it is hindering my ability to use and enjoy the property, and I'm requesting that you do XYZ to accommodate me, the landlord has to engage in the interactive process and have a conversation with you about that they can't just outright deny it. If they outright deny that request, that's disability discrimination. So without getting into a long seminar about disability discrimination, if you do have special medical conditions, you can make a reasonable accommodation request. And also just backing all the way up, baseline, going to the first slide about habitability, even if you don't have a disability, the landlord is required to maintain the property in a habitable condition for people who have asthma and for people who don't, right? So that is a baseline obligation. And also if you have health conditions, you can also make reasonable accommodations related to that.
Great. Okay. And so I want to make sure I understand this correctly, but so is there a line where somebody would say this unit is not habitable? Like, is that called by the landlord, or would the tenant receive something to say, we all agree this is not habitable, therefore X is going to happen? Like, when does that happen?
So yes, I mean, there is something that is sometimes called like a red tag, but a government agency, sometimes they'll go out, they'll, you know, inspect the property. This happens sometimes with illegal, unpermitted units. The government inspector will go out and they'll issue a citation and they'll say, this property has XYZ, these are the things that are wrong with it. And then order the landlord to fix it within a certain period of time. And if the landlord doesn't fix it in that period of time, they can be fined. And so getting that government citation and determination is definitely helpful in terms of the law and how the law treats these things. It's good to have that, to have your evidence of like, look, the government came out here and cited it. Does that answer your question?
I think so. I hope so. First of all, let us know. The other question we had was about insurance, which I'm not sure if you're going to know the answer to, and I'm going to do my best to interpret it. But somebody was wondering if for personal contents that were destroyed, they were wondering if that content, if you have to list out the content individually in detail, if the loss was more than 30% of the total contents in the policy. I think that's how I understand the question. I'm not exactly sure.
So I'm not an insurance expert. I did go to a pretty good insurance training though. And but what I remember from it is, you should try to list everything you possibly can, come up with whatever evidence you can of the value of it. But everyone's insurance policy is different. So you have to read it carefully and work with your adjuster. Yeah.
Thank you. And then someone asked a question. They were finally given a date to have an organization come through and go through the rubble of their home. And they didn't know if there was anything they were obligated to give the landlord based or that the landlord needs to send them, I guess. Is there any paperwork or documentation that needs to be distributed between the landlord tenant if like Samaritan's Purse, a not-for-profit, is coming, right, to kind of go through the rubble?
When you say rubble, is this for a fully destroyed?
They don't say, but I'm thinking that just by the language they're using.
What is the question?
I guess, like, does the landlord need to be notified? Does the tenant need to be notified if people are actually on site going through the contents of the rubble?
I don't actually, I'll be honest, I don't know. I would think yes. I would think if someone's going through your belongings, you should be notified. Do you agree, Gigi? But I'll be honest, I haven't researched that. But I think if there's a company coming out and they're going to be going through things that are your personal belongings, you should have a right to be present for that.
Great. Okay, thank you. And then are you guys aware, we can also do some research too for this question, but do you know of any free or low cost testing for contamination or ash that's available? Um,
We can look into that. I don't have anything just, that I've gathered already, but
okay.
yeah,
I think there's a lot of concern about the stuff that's not seen, right? Like
right,
how are we aware of what's there, but we're not really seeing it?
right.
Okay, great. And then what's the period of time to remediate that the landlord has to remediate, right? So is there a period of time when the landlord has to be responsive to remediation?
This isn't a cut and dry answer. So if, like I was mentioning, if a government agency goes and cites the property, they will give a deadline. They will say the government will do that. They'll say in 35 days, in 45 days, you have to fix these things. And if you don't, we're going to come back and inspect it and you're going to get fined and things like that. In general, if there hasn't been a government citation, no. I mean, they should do it as soon as possible. It's their obligation to do it as soon as possible within a reasonable time, but there's not like a law that says, there's fire damage, the landlord has to fix it in X number of days. I don't know if that answers the question.
Yeah, I think it's just if the landlord isn't playing nice, right? Maybe they aren't being communicative, or there's a sense from the tenant that there isn't really a lot of movement on the remediation, right? And the tenant is unhoused. But it sounds like if I'm hearing you correctly, it sounds like they need to do sort of what's customarily responsible, right? In the way that a lot of these systems are backed up, but there needs to be some action.
Yeah, and I would say if that's the case, then if you want to speed it up, get a government agency out there to cite them and they'll give them a deadline.
Great.
Yeah.
Okay. Another question about habitability. So if the landlord is claiming that the apartment is habitable, right, but the tenant is going in and there's significant piles of ash inside and outside, it's not sort of what the tenant would deem as habitable. Could you speak a little bit towards what actions the tenant might be able to take?
I'm wondering if we might go over this later
Okay.
I think we go over this later in the presentation. Maybe we can come back to that one.
Great. Okay. And I think we have all the questions, everybody. So I think we should go ahead and go to our next session, Elisa, just because we have a lot more to cover.
Sure.
And we certainly can circle back if we missed anything in this particular section.
Okay, great. I'll hand it over to Gigi.
Next slide, please. We've had some questions about security deposit and when do you get it back after you move out of the unit? State law says that the landlord has 21 days from the date that you move out to return your deposit. They can also deduct from the deposit for certain things, such as unpaid rent, repair of damages caused by the tenant, and cleaning. But the landlord cannot keep your security deposit to repair damages caused by the fires. And if the landlord does not return your deposit within 21 days of you moving out, then you can file a small claims case. We have a sample demand letter that you can send your landlord. Next slide, please. Some folks have had to move out in January because of the fires. And if you have moved out in January because of the fires, you are entitled to the return of your January rent from the date that you were required to move out. If your home was fully destroyed, if your home was severely damaged, or if you were subject to a mandatory evacuation order. We also have a sample demand letter for the sum of your January rent. Next slide. Okay, so there are obligations to pay rent moving forward. And we have separated in 3 categories. So if your home was fully destroyed, then your tenancy has ended. There's no obligation to make future rent payments. It just means, there's no longer any landlord-tenant relationship between you and the landlord. If your home was severely damaged, because it's unsafe to live there. It was red tagged by a government agency. The tenant does not owe rent while the home cannot be lived in. And I want to put like an asterisk here that you have to be cautious when you withhold your rent if your landlord disagrees whether this home can be lived in or not, especially when there are no government order that has cited this rental unit. And once the home has been repaired, then the tenant will continue to pay rent. If your home has minor damage, you still owe the rent. You can potentially negotiate with your landlord for a rent reduction. Again, in all of these situations, the best scenario is that you contact the local government entity that deals with this type of issue. So we have provided a bunch of links. It's always best to have a government agency saying this home was fully destroyed, or I mean, some of that is obvious, whether it is severely damaged or whether there has some minor damage, because the landlord is obligated to provide you with a rental unit that is habitable at all times. Next slide, please. Okay, Elisa spoke a little bit about the relocation assistance that some tenants can be entitled to. All of that depends on where you live and how damaged the rental unit is. So no matter where you live, you're not entitled to relocation assistance if your unit was destroyed or if your unit has only minor damage. The reason you don't get rental assistance if your unit was destroyed is because there's no longer a relationship between you and the landlord. You can move out and you get your security deposit back. If your unit has only minor damage, that means you can still live there. You don't get relocation for that. You may be entitled to temporary or permanent relocation assistance if your unit has severe damage, or if you live in a unit that is protected by a rent stabilization or just cause ordinance. This is very fact dependent, and we recommend that you consult with a lawyer before you claim that you get some kind of relocation assistance. Speak with an attorney first. It's very technical. Next slide, please. Okay. Yeah, next slide. Okay, so continue on with this train of thought about relocation assistance. Most local just cause ordinances, it just means the landlord has to have a reason to evict you in these type of jurisdiction. There are specific rules and procedure that the landlord has to follow if they want to temporarily or permanently move you out to make repairs or to comply with a government order. For a temporary relocation to complete repairs, the landlord is required to give you a detailed notice and offer replacement housing or some per diem payment. When you are permanently being asked to relocate, that means you no longer will live there. You're not even coming back there. The landlord must serve you with an eviction notice saying you have to move out, and they have to pay you with relocation money. Again, these type of protections can be very fact specific. So please consult with a lawyer who specializes in landlord-tenant law before you determine if you are entitled to relocation assistance or not. Next slide, please. Any questions? I know that was a lot and it was very fast, but yeah, we're here to answer your questions.
Great. Thank you, Gigi. I'm just getting them from Rebecca. So we did want to clarify or go back, and maybe you could say it again if we just didn't get it. So sorry for the repeat, but if the landlord is saying that the unit is habitable, but the tenant is really feeling like it's not habitable for them, could you just explain one more time what their recourse is?
So what I would recommend in those type of situation is the very first thing, you need to contact the the government entity that is overseeing that area. Like Elisa mentioned earlier, if you are in the city of Los Angeles, there is a specific government agency that deals with that. It's the Los Angeles Housing Department. If you are in the county of Los Angeles, including all of the unincorporated cities of Los Angeles, you would contact the health department. And then for Pasadena, they have their specific public works, and there's also building and safety. So it just all depends on where you live, but you don't want to be involved in a he said, she said situation. I think it's bad. You don't think it's bad. It's always best to have a neutral government entity saying this is bad. What you can also do, but it would be out of pocket, is that you can also hire a private agency to conduct certain tests and have the proof. But yeah, I think as many proof or evidence you have that the conditions are bad, the stronger your argument will be against the landlord who says, oh, that's not so bad.
Great.
Does that answer your question?
I think so. And just for all of us listening, because some of us may be newer to this than others. So the first thing that you need to do is to go back to those original links that we were given at the beginning and put in your address and begin to figure out where you live. Because if I'm understanding you correctly, Gigi, that's actually going to inform what entity, what government agency you would reach out to formalize your complaint, or to say I'm concerned, or we're having this disagreement, or can we get some kind of inspection or complaint? Is that right?
That's right. So what you can also do to make it very easy is that you can just call 211 and then they will direct you. But
great.
A lot of times 211, there could be a hold. So in our slides, we have specific links, and it just starts like, okay, if you think that you are in the city of LA, but you're not sure because maybe you're on the border, you would plug in your address there. It's going to tell you that you're in the city of LA. And then in the city of LA, then, we have a link for the Los Angeles Housing Department. If you think that you're in the county of LA at somewhere, maybe you're in a city in the county of Los Angeles that's not incorporated like Pasadena, then it would be unincorporated. You plug your address in there. But we have all of those links in our slides as well. So you can just follow the headings.
And is it, I think you had said this too, it would be within the tenant's rights to ask for whatever the report was, right? So if the landlord is saying, no, we got it inspected, it got the red stamp of approval, it would be within the tenant's rights to say, could I please see the report? Is that right or not right?
That is right. You are entitled to a copy of the report. Also, if the inspection was conducted by a government agency, you can contact the government agency and get a report. You can go to the counter and get a copy of that. I think you might have to pay 10 cents per page for the printout, but that would be the only cost.
Okay, thank you so much. All right, so here's some other questions. So our landlord building manager is using a cleanup service and air testing for smoke and ash. Does the housing inspection link that you sent provide services to verify that it was completed to a certain health standard? So again, people being concerned, right, that they said they did the remediation and it was all okay, but how do you scale that being acceptable?
Yeah, so the housing department, they don't, they have their own workers and they go through like a procedure. They will let you know when they're going to come, but they do not assess whether some independent contractor has done the work correctly. But if your landlord has completed certain tests, you still feel unsure about it, you should continue to contact whichever government agency that's overseeing your area and just make sure that they also come out and then, cross-reference. But, with any government agency, there is going to be a delay when you contact them. But if you keep contacting them, give them like, a week to get back to you. If they haven't, keep calling them, and a lot of these you can actually complain online or request an inspection online. So you have those alternatives as well. But I would say just to continue to check in on them, and they will send somebody. And before they send somebody, they will coordinate with you to make sure that you are there.
Okay, great, thank you. Our next question is, should we be paying utilities if we don't have to pay rent because our home is severely damaged?
Well, it depends. Is the utility part of your rent? Then of course you don't have to pay anything. Usually if the utility is in your name, a lot of times you can just contact the utility company and ask them to just pause on that because you're not using any utility. And especially if your home, you don't even live there.
Great, okay.
Yeah.
So if my unit wasn't under a mandatory evacuation, but it was close enough to a zone under mandatory evacuation, could the tenant break their lease based on fear of smoke damage or toxic chemicals?
I think it depends. You know, if your home was severely damaged, and it depends how much of your lease you have left. To be honest, I don't think it's a big deal to break the lease. I have friends that say, "Oh, I need to break my lease." I say you can always break the lease, of course, because I'm also an attorney. I do say there could be repercussion, right? You are responsible for whatever duration of the lease. But in my experience, the landlord will never go after you. We have never heard of any. So we want to say there's a caveat, but you can always break the lease, basically. Yeah.
Okay, thank you. This is a little bit more of a specific question, but it said we have somebody that was living in a green tagged building in the Palisades. There was heavy ash and soot inside, and they weren't allowed to go back in for a couple of weeks and had no power. Do you have any ideas? Will they be able to deduct those 2 weeks, I guess, from their rent payments? So if they were mandatory, they were on a mandatory evacuation, they couldn't get back to their home for a certain amount of time. Are they able to deduct those evacuated days from their total monthly obligation?
Alicia, you want to chime in here on this one?
I think kind of just going back to what we mentioned in the beginning of just if you have severe damage and it was unlivable, it sounds like this person was in the Palisades, was like utilities were off really bad. This is like a very bad, not habitable situation. They were completely unable to, they're mandatorily evacuated, etc. In that, even though this is one of the tricky things, like some of those places, just because of the overwhelm, and there was, the government agencies can't inspect 1 million units at the same time. But given the severity of the conditions you just described, I think that tenant would be well within their rights to demand a refund of if they paid rent for that period that they were displaced.
Okay, great.
I just want to say that you have to demand it first. Yes.
And we did have, there was a question about the demand letter, and I know you guys said you have a sample for us. So we'll make sure that there's a link to that demand letter, or everybody that's on today or registered will get a sample of that demand letter.
Yes. And the demand letter is very easy to follow. There's space where you put your name, your address, and check boxes. Everyone should be able to use that. Yeah.
Great. We have a question if there's a difference for renters' rights for a single family home versus people that are living in apartment rentals.
It depends on which area in Los Angeles County you're in. Yeah. And even so, there could be some technical defenses that you can't see just from that location. But I would recommend that wherever in town that you are, I would plug in the address and find out, what is the closest jurisdiction, right? Like, is it City of LA? Is it County of LA? But even for multi-family, even for like a single family residence, there are some protections, just depending on where you are.
Okay.
I'll chime in really quick. For the 3 jurisdictions we've been talking about, Pasadena, City of LA, and the unincorporated county, single-family homes are protected by just cause protections. There's not rent control, like the government can't control how much your rent is, but there are just cause protections for the vast majority of units in those three areas. So that's a complicated subject that we could go on and on about, but yeah.
Great, okay. And then again, if the tenant disagrees with the landlord's assessment that the unit is habitable or inhabitable, yeah. If there's a disagreement, what is their course of action?
They can sue the landlord if there's negligence. Yeah.
Okay, and how do they go about doing that?
It depends on how much the damage is. So if the damage is under a certain amount, I think it's 11,500 now, they can do a small claims. It just all depends, and I wouldn't do anything first without sending a demand letter. You would start there. So we
Okay.
have various demand letters for, you know, you need to reduce my rent because the conditions are bad. You need to return my security deposit because I've moved out and I haven't received it, and I'm going to sue you if you don't return it. So yeah, I think we have 4 demand letters or 2 samples. It should cover most of the things that are being asked right now.
Great, thank you. We do have more questions, but I wondered if should we go on for the PowerPoint?
Probably.
I think so, just because we're a little at 1 o'clock. So
Yeah.
I'm not sure how much more we have to go. So why don't we pause here and get back to our presentation, and then we can circle back to some of the unanswered questions.
So this is the portion of the presentation about recent laws. Some have existed in like the harassment protections, but so there's been some new laws that have come into being after the fires. So let's go to the next slide. So I'll try to go relatively quickly. People may have heard of the price gouging protections. Generally speaking, this just means landlord, like all kinds of different, it applies to landlords and rental housing, but it applies to a lot of different things. Basically, you can't raise prices more than 10% during a state of emergency. We're in a state of emergency. We will be in a state of emergency until January 7th, 2026. So, you know, if you are looking for a new unit and you go on Zillow and you can tell that the landlord has raised the rent 50%, that's price gouging, and you should report that. So, and next slide. These are the places where you can report it. I know I've seen some, you know, there have been some lawsuits filed both by private agencies and the government against landlords who are engaging in this practice. So it is worth reporting if you are a victim of this or if you notice it happening. On this topic of rent and, you know, your landlord trying to increase your rent, in addition to the 10% cap that the price gouging law imposes, if you live in a rent stabilized unit, which generally speaking is a multifamily unit that's older than 1978 in the city of LA or 1995 in, I think, both Pasadena and unincorporated LA County, you already have rent control protections, meaning your landlord can only increase your rent a certain amount per year. So right now, we just wanted to inform people what the percentages are in each of these places. In the city of LA, it's 4%, and then the landlord can add an additional percentage if they pay for gas and electricity, certain utilities. So like for me, I got a 6% increase because I don't have to pay for my utilities. My landlord pays for all of them. In unincorporated LA County, the current allowable increases depend on what type of unit it is. So for just regular units, it's this 2.565%. For what are deemed like small mom and pop landlords, they get the 3.565%. And for luxury units, the rent can go up 4.565%. And also for all of these situations, the landlord can only increase your rent once every 12 months. So that's just a general rule when you're in a rent controlled jurisdiction. The rent can only be increased once a year and there's a cap. Pasadena, it's 3%. And if you don't fall under any of these local laws, the statewide Tenant Protection Act also has a cap at 8.9% right now. Next slide. Go ahead, Gigi.
All right. So if you live in the city of LA, if you live in unincorporated LA, if you live in Pasadena, you are protected from landlord harassment. And there are a broad range of actions by the landlord that can be considered harassment. Next slide. And for example, if your landlord stops making repairs, if they try to change the terms of your tenancy, if they just refuse your rent, if they report your activity to a government agency, if they ask about your citizenship status, any of those things, you need to immediately contact in the city of LA, the Los Angeles Housing Department. In unincorporated cities of LA County, you will contact the Los Angeles County Department of Consumer and Business Affairs. If you are a Pasadena tenant and you feel that the landlord has done various acts to harass you, trying to drive you out of your unit, you can go online at this link and contact their housing counselor. So with all three, you can lodge a complaint and then they will take it from there. Next slide. Oh, back to you, Elisa.
Okay, so you may have heard there have been some things recently passed to protect people who have taken in additional people because of the fires. So the first thing that happened is on January 17th, the governor did an executive order that just basically said for all of LA County, you can't evict people based on an alleged breach of their lease agreement, because most lease agreements have a cap on how many occupants you can have. He suspended that. He just said anyone who has displaced fire victims living with them, they can't be evicted for that. And that, as far as we can tell, is expiring in a few days. But that was applicable to all of Los Angeles County. Next slide. The good news for people who live in the city of Los Angeles is that the city council has stepped in and passed an ordinance protecting both people who took in occupants and pets. So there's a lot of stuff you have to prove. Unfortunately, they made it really onerous. I'm not going to read this whole slide, but you do have the potential to have protection from eviction if you took in additional occupants or pets, or if you had to move in with someone who has a lease that says they can only have 2 people and now you're living with them with your dog, you should let them know there's this protection in the city of Los Angeles that says, you know, that person can't be evicted for having additional occupants and pets, as long as they jump through all these hoops, which include a lot of disclosure, names, dates of birth, descriptions, but as long as you comply with all of that, and in particular, note the deadline, March 25th, 2025, as long as you do all the disclosures to your you do the disclosures to the landlord by that time, you should have protections for the additional occupants or pets. Something that's important to note is these are not self-executing protections. In other words, the landlord can still try to file a lawsuit. Anyone can file a lawsuit. That's just a general American thing. But, you know, what this protection does is it gives you an affirmative defense. But you still have to go to court. You still have to defend yourself. But the landlord should not be successful because you will have this affirmative defense. The final thing about this is usually in the city, what we call LARSO, the LA City Rent Stabilization Ordinance, typically, if you have an additional occupant, the landlord is allowed to charge an extra 10%, increase your rent 10% per occupant. So this protection also suspends that. It says if you have additional people because of the fires, that 10% increase isn't applicable. Next slide. Okay, this is what the newest protection. The county, DCBA, or the Board of Supervisors, recently enacted this resolution that is specifically about non-payment of rent. It covers and applies to everyone in LA County, so probably everyone who is on this call. As long as you live in the County of Los Angeles, this may apply to you. Again, as similar to what I just mentioned, it's not self-executing, it's an affirmative defense. So it's something that you have to bring as a defense in court. The landlord might still try to sue you in eviction for it, but you will have this defense if you, you know, fulfill all of its requirements, which we're going to get to on the next slide. But the basic tenets of it is for the period from February 1st, 2025, so last month, through July 31st, 2025. If at any of those months you're unable to pay your rent due to reasons that are related to losing income because of the fires, and that's defined, and we're going to look at that, and we'll see that in a second, you'll have protection for being evicted for not paying. And there's a year repayment period. So you have until the end of July 2026 to make up those payments that you missed between February and July of this year. Next slide. So these are the here's the fine print. You have to have lost actual wages due to your employment or place of business being destroyed or being uninhabitable because of the fires, or your landlord laid you off or reduced your working hours because of economic impacts related to the fires, or you had clients that were located in the wildfire area and that resulted in a loss of income. Next slide. And also, they made a lot of criteria for this one too. You have to, again, provide notice to your landlord, and it has to be done within 7 days of the rent due date. So any rent you're going to miss, you have to provide notice to the landlord that you're not going to be able to pay. This is a link that will be provided with the presentation to the county has already created the form. It has checkboxes and it's pretty clear and easy to follow. So you can just print that out, fill it out, make sure you get it to your landlord before 7 days after the rent would be due. Unfortunately, for February 2025 rent, the due date for that was yesterday. So February might be too late unless you knew about this before this presentation. Other requirements include that you had to have lived in the unit before January 7th, before the fires. You have to have lost at least 10% of your average monthly household income. And you have to show, you have to have applied for wildfire relief, unemployment benefits, or you have to basically declare that you have to be actively seeking employment. And all of those things are like check boxes that you fill out on the notice that you have to give to your landlord. And finally, your household income must be equal to or less than 150% of the area median income. And I was going to include a chart that explained what that is and forgot, but we can circulate that after the presentation, how to figure out what 150% of AMI is. Next slide. I'm going to pass it over to Gigi.
I was going to post a picture of the 150% AMI, but we can circulate that later. So if your landlord tries to evict you, you need to contact Stay House LA immediately. You can do that online or you can call them, and you will be connected to a legal service agency in your area. And if you receive an eviction lawsuit, it's going to say summons and complaint. You need to respond to that lawsuit. You need to answer within 10 days. You can do that online by using the Tenant Power Toolkit. It's going to ask you various questions and it's going to generate a response for you. You can also contact Stay House LA for assistance with an answer. And you can also go to the self-help center of the courthouses listed on this lawsuit. And I also want to add that Stay House LA also conduct every day. There's a workshop, there's a clinic, and with most of those workshops and clinics, a lot of them are remote. You can have a one-on-one consultation with an attorney, just so that you get more information if there's anything that we miss here. Next slide, please. Okay, so strategy considerations. I've heard a lot of questions about, my landlord's not doing this, my landlord's not doing that. Like, how do I prove them wrong? I think the approach that makes sense for you depends on your specific situation. Like, what is your relationship like with the landlord? Sometimes calling code enforcement or government agency, sending demand letters, and threatening the landlord with litigation, it might make your relationship with the landlord more tense. Sometimes it might be necessary, but I think before you do anything, I would always try to approach any situation, just a one-on-one conversation. Hi, landlord, this is what's going on. Can we resolve this? And if your landlord is being unreasonable, then, you got to do what you have to do. If you have a good relationship with your landlord, I feel like it's always best to just try to get them to cooperate and resolve that informally first. Withholding your rent, even when you're right, it could lead to an eviction notice. It could lead to an eviction lawsuit where you have to prove that you're right. And being in a lawsuit, coming from a lawyer who does this type of work, is not fun. So I feel like if you can informally resolve what you need to resolve, I would try that approach first. If you are out of possession, if you no longer live in your unit because of the repairs or whatever, I want to make sure that you have a stop hold on your mail with the local post office and just check it there so that you don't miss any mail. Yeah, anything you want to add here, Elisa?
I don't think so. Yeah, the point of the last bullet point was just to, if things are getting kind of testy with your landlord and, you're not living there full time because you can't be, or you're waiting for repairs to be made. We do see some landlords who are sneakies. I heard someone talk about this at one of the clinics I attended where he had a Ring camera and his landlord knew he wasn't there because he was waiting for the property to be remediated, and he had renter's insurance that was going to help him with that and everything. The landlord tried to post an eviction notice on his door while he wasn't there. So you just want to be monitoring. I'm not saying everyone has to go out and get a Ring camera, although that might be a nice thing to have, just so you have like the ability to monitor it from afar. But the first step in every eviction case is them serving a notice, and if they can't personally serve it on you, they can post it on your door and mail it. So just that's the reason for, if things are getting testy with your landlord, you think they might try to serve you with eviction paperwork, just be monitoring the property even if you're not there. I think that's it.
Any
Great.
questions?
Yes, thank you so much, you guys. So we do have a few more questions. One was specific to just being evicted, and they were wondering, so they were evacuated for 3 weeks. They're still paying rent, but the landlord wants to evict them, is wanting them to leave. And they were wondering, just in general, with the eviction order, the no eviction order that you just talked about, can they, or would they be eligible for relocation assistance? Or can they stay, just because of the current circumstance? But it sounds like, I'm going to broaden your question first. So when you talked about the eviction merits, what I sort of circled in my mind is they have to meet all of those merits, right, to avoid being evicted. Is that correct?
Okay, this requires backing up.
Yes.
So again, it's hard to give very, very general advice about this, but if you live in the city of Los Angeles, Pasadena, or the unincorporated parts of LA County, you have just cause protections, which means your landlord cannot just, you most likely do. There are some properties, so again, caveats, there are some properties in each of those areas that are exempt for reasons, but the vast majority of rental housing is protected. So if those laws apply, and they very well may, the landlord is not legally entitled to just say you have to leave for no reason. They have to have a just cause. Just cause includes things like you did something wrong, you didn't pay your rent, you breached your lease agreement, you created a nuisance, you engaged in illegal activity, or there are also what are called no fault reasons for eviction. So the landlord wants to move in themselves or a family member. the landlord is taking the rental property off of the rental market entirely, in which case they have to take all of the units off all at the same time, and they have to pay it. So all of the no fault causes, just causes for eviction require the landlord to pay relocation assistance. So what you're trying to avoid is getting in a situation where your landlord can claim that you can be evicted for an at fault just cause, like non-payment, like breaching your lease, like creating a nuisance, illegal activity. Or am I forgetting one, Gigi? Like those are the ones that you don't want to be putting yourself in a position of your landlord saying you did it, because if you are at fault, they don't have to pay you relocation assistance. I hope that kind of answers or touches close to what that question was. The things that we talked about in the protection section are on top of the just cause protection. So on top of the regular baseline of the just cause protections, now there's specific additional tenant protection. So normally you can be evicted for breaching your lease. However, right now, you can't be evicted for breaching your lease if it's because you have additional occupants because they were displaced by the fire and you meet all those criteria.
Great. Okay. And we have a couple more questions just again about landlords not playing nicely. So if the landlord is not testing for all the things, does the client or does the tenant report them? Is that their action item is to report them if the landlord is not testing?
Did you want to, I think yes. I think demand letter, report to government agency, none of that works, then potentially start looking for a lawyer.
Okay, great. And there was one more. So I guess in all of these questions, right, people are starting to get really granular because they're experiencing some very specific things, and just want to circle back to resources that I know if people I know we know Stay Housed very well. So the Entertainment Community Fund, we use Stay Housed all the time, but Stay Housed is a tool, right? Is a place for people to go to call. The Housing Rights Center is a place for people to call. So we can send everybody some resources of places you can engage with to get some of your specific questions answered. Also, Gigi and Elisa, you'll share with us maybe some of the criteria for Public Counsel so people would know. But there are resources out there for people to get support around some of their specific questions.
I don't know if you just mentioned this, I'm sorry, because I was just looking at something else. But the other thing is Neighborhood Legal Services is still, I believe, this whole month hosting weekly on Wednesday presentations, and then so the presentation will be very similar to what we just did. It'll be repetitive, but then they also have like one-on-one consultations. And it's virtual. So we can try to, I'll write down to send over that information too.
That's great. So just to reiterate, we'll be sending everybody, if you are wanting to connect with somebody one-on-one, there is this opportunity on Wednesday nights to do the presentation and then connect on a one-on-one, kind of like a clinic, to sort of have some of your more specific questions answered.
Yeah, it's actually Wednesday, like midday, but yeah.
Midday, okay. Great. Let me just check and see. So I guess same thing, if the landlord is reluctant or not willing to pay the relocation assistance, that might be a situation where somebody would need to gain support or representation, or can you speak to that?
Yeah, and what I'll say as a general principle to that is your leverage in any of these situations with your landlord is by staying in possession. Don't give up. Keep insisting, I'm not giving up my tenancy. Because they don't have any incentive to pay you anything if you just give it, if you give up your rights to be there, right? So yes, I would, it's probably something you want one-on-one counsel and advice about, but just the thing that comes to mind whenever people ask about like negotiating or trying to get money as a baseline thing, is just make sure that you are aggressively asserting that you haven't given up your tenancy, you haven't given up your right to possession, you're still, in the unit, and you will be in the unit unless and until whatever your conditions are, including money. If it might not work, at the end of the day, sometimes negotiation doesn't work, but.
Thank you. And lastly, I guess, just do you guys have any specific tips or traps that you could recommend to everybody just as everyone continues to navigate the next few months?
Document everything. Keep a journal whenever you talk to your landlord, whenever just, it's easy to forget things. So just write everything down, take pictures, even if it, just keep taking pictures every week, every other, so you just have all of your records, because that's your ammunition.
Yeah, and I think, the first thing that you need to figure out is like, where in LA are you? And then I would go to that government agency that oversees your specific area. And there's a lot of information out there, but it's just too much. So I think once you narrow down, where am I? You figure that and you go from there. Excuse me. So yeah, that's what I would do.
Wonderful. Okay. Well, thank you so much, Gigi. Thank you so much, Elisa. We really appreciate you spending your time with us today and sharing your great information. Everybody, we will be sending a follow-up of this recording and all of the resources that were placed in the chat with the slides in a follow-up email. We also just want to emphasize that all of our community partners participating in hosting today's events are offering a wide range of services, some of which include emergency financial assistance, mental health support, and practical help, helping everybody connect to resources. So if you're feeling overwhelmed, you're feeling like you could need some help and support, we really want to encourage everybody to reach out. We're here to help. So take good care, everybody. Thanks again, Gigi and Elisa. Be
Thank
well,
you.
everyone.
Bye.